Three gun charges for Hunter Biden. One, a false statement in the purchase of a firearm. Another is a false statement in that same form, essentially, required to be kept by the firearms dealer. And then the third count is possession of that firearm while being an unlawful user of or addicted to a controlled substance. For more on this, let's bring in John Lott. He's the president of the Crime Prevention Research Center to react. John, good to have you with us, sir.
It's great to talk to you again. Thanks for having me on.
John, you did point out some months ago that that at least three charges were warranted here. Are these the three?
I would have done it slightly differently, but I said three or four. One interesting thing is they have a separate charge for lying on the form that you thought, the 4473, where they explicitly ask you and you're supposed to sign that, you go through things. Have you been dishonorably discharged? Have you been, are you using controlled substances right now? Other things. And, that's one charge, clearly. They're also charging him for making false statements to the gun dealer, which is a little bit unusual there. The other one, so I mentioned the 4473. I'd mentioned the one where he had illegal possession of the gun. They've kind of combined that with illegal possession and interstate transportation. It seemed to me, and when I was talking to before, that those are two separate charges that were there rather than lumping them together in one. And that's the way they normally would be charged, as two separate ones. So if they're going to do it their way, I would have broken down the third count into two, and that would have given me four.
Right.
One of the things is literally within a couple weeks of the original plea deal, when it became public for Hunter, there was a case in Virginia where a woman was charged with lying on the 4473. She was using marijuana, not cocaine, like Hunter, and she got two charges. She got charged for lying on the form and also illegal possession of the gun while she had the controlled substances that she was using. And so, it's just strange. And one of the things you frequently hear in these discussions is how few people are charged with violating NICS standards for buying a gun. But what most people don't understand is that, so Biden and others will say there have been 4 million dangerous or prohibited people that have been stopped from buying guns because of background checks. What they really should say is there have been 4 million initial denials. And about 99% of those are mistakes. The reason why they don't charge them, it's one thing if it's a felon, somebody who's prohibited from buying a gun. It's another thing if somebody simply has a similar name, roughly phonetically similar name and similar birthday. And that's what about 99% of the cases are. And so when they say that people are rarely charged for these things, that's simply false. I mean, if the rare charges are the ones that are dropped because they got the wrong guy.
Right.
When they actually do have the right guy there, they charge them all the time. These are usually very, very simple cases. I mean, one of the bizarre things that I'm sure you've pointed out is, this goes back to 2018. These are cases that you deal with literally within a couple weeks, not years, to try to go.
Well, the statute of limitations was just about to run out on this one, I believe.
No, I know. Yeah, I know. For 5 years.
Yeah.
And it's just, so, I mean, it's just bizarre.
Isn't it?
How they've handled it.
It is bizarre. And it was going to be just written off a couple weeks ago. The plan was to essentially give him blanket immunity to all of these charges. And then that fell apart in open court. And now we are looking at David Weiss bringing these charges. One of the interesting features here is that Weiss could have always brought these charges on his own accord. This didn't require other U.S. attorneys to be involved. All of the activities in question occurred in Delaware, and they're only just bringing the charges now.
Yeah, I don't know. One of the things that gets pointed out often by kind of the mainstream media is that Weiss was appointed by Trump and that's true. But he was originally appointed as acting U.S. attorney for Delaware by Obama.
Yes.
And you have a situation where any of these kind of judicial type appointments, the senators from the state can go and use what they call blue slips,
right,
to block the person being considered. And in a place where you have both the senators being Democrats, they could have killed the nomination. So essentially, Weiss was someone that both the Democratic senators from Delaware wanted to have. And so it was either basically giving them what they want or not having anybody there being a full acting U.S. attorney.
Right, yeah. Chris Coons and Tom Carper handpicked this guy, and then everyone pretends like he's a Trump dude. And here he is, he arranged this gigantic sweetheart deal for Hunter Biden. They got caught with their hands in the cookie jar, and now this is the result of all of this. Now, there's another piece of this I was just talking about, John, which is that 2018 is when all of this goes down, the gun purchase, and then subsequently when the gun gets thrown into a trash can by Haley Biden, and it begins a series of crazy events. This is all occurring in Delaware. But Politico reported that the Secret Service got involved, that Secret Service agents actually went to the gun store to demand the paperwork that the gun dealer had on file. And the gun dealer said, I'm not giving it to you. He suspected something was up. I'm not giving this to you. He would eventually turn it over to ATF, reportedly. Secret Service has denied any involvement in all of this, but this all stinks to high heaven.
Yeah, I mean, it raises the possibility that Joe Biden was involved in it to some extent. I mean, who knows?
Right.
I mean, obviously, one's going to have to go and investigate this much more carefully. I heard earlier on the news that Comer and Trump had made comments with regard to this not involving Joe Biden.
Right.
To me, if I know Weiss is unlikely to pursue this, but what you can do is you can use these types of charges to extract, a deal with the person there. That's normally what would happen. I mean, here we have very serious bribery charges and other charges that could be there, and they could use it to go and bring in Biden, even though it may look like they're ones that don't involve Biden directly. Whether Weiss is motivated to do that or not, I have no idea. But I guess we'll just have to see. But it doesn't seem like there have been any really serious investigations into anything that deals with Joe, as the IRS whistleblowers and others have made clear.
Right. So with a case like this, as it relates to Hunter Biden, I've seen some headlines saying that Hunter Biden could be looking at a maximum of 25 years in prison for the charges in question. In your view, is that realistic in any way?
I think it's unlikely. I mean, I think, if this was a typical person, you'd probably be talking about someplace between 5 and 10 years in prison. I assume he'll be pardoned at some point. I assume he knows that would be the case.
Right.
So I kind of doubt he's going to face anything. If he was any normal person, he'd be in jail for at least 5 years.
So now let's move on to the legal defense that Hunter's team might mount here, which I think is kind of interesting. The first line of defense is they claim they already have an agreement.
A diversion agreement.
The diversion agreement. They say it's signed already by David Weiss. So in all of the chaos of that court hearing a little while back, there were signatures from both Hunter Biden and David Weiss put on that form. And what Hunter's lawyers are right now arguing is that's legally binding. In other words, he has blanket immunity from all of this, and this can't move any further forward. Now, if it does happen to move forward anyway into a trial, there's been some claim here that this is unconstitutional, that these types of barriers to Hunter Biden buying a gun, demanding knowledge of his drug use, is actually unconstitutional. And now Hunter Biden's team is becoming, sort of radical, fierce defenders of the Second Amendment, no restrictions whatsoever. What do you make of that?
Right. Well, yeah, you raised several points, but I'd actually have to see the diversion agreement. I mean, one of the things that could happen is it could be a diversion agreement with regard to the original charge that's there. Obviously, there was a lot of shenanigans that went on with the original plea bargain in terms of hiding protections against future charges and other in different parts of the agreement that was there. And that was one of the things that upset the judge to begin with. And but now we have new charges that weren't brought. I have a hard time believing that a prosecutor could do a diversion agreement that would promise that I won't bring any future charges against you. That just seems too much to believe that was actually in the agreement. And that may be one reason why they've gone beyond the original charges that were in the plea agreement that they had. But again, I haven't read the diversion agreement. So
I did. In those two files that were put before the court, they offered broad immunity for anything involving any of the facts that were detailed in the court documents. And that was extensive. It involved all of Hunter Biden's business dealings. It involved everything related to this gun. It were comprehensive. The only thing that it allowed for, quite obviously, is any future allegations of future crimes may be charged, which is unbelievable. It was basically blanket immunity for everything that Hunter Biden had done up in his life up until that moment. And so Hunter's team is arguing that's the agreement. We all signed it, and it's binding. I guess we'll find out if that's true.
Well, I mean, diversion agreements don't involve a judge. I mean, it's just an agreement between a prosecutor and the defendant there.
Yes.
And they're usually binding because the claim is that in exchange for the diversion agreement, some other type of information was provided by the defendant to the prosecutor, and in order to go and give that information, it's reasonable that they're given certain legal protections in return for doing that. But I have to tell you, to go and say that any possible charges that we can bring, we're going to exempt you from that. That's pretty astounding. I mean, I was chief economist for the U.S. Sentencing Commission. I've worked in the Department of Justice, and I mean that's an amazing diversion agreement.
It's amazing.
Something like that.
It's amazing, and every prosecutor who's taken a look at this thing says they've never seen anything like it in their life. It is just, and this is the country we live in now. All right, thank you very much, John Lott, for your reaction to the breaking news today. Really appreciate your time as always, sir.